concerning the case Edwards v. Morneau-Sheppel that took place at the Brampton Court in 2012. To date, in apparent negligent denial of documented facts, the Ontario legal industry has refused to hold the professional misconduct of its lawyers Pamela Mills and Roslyn Cogan accountable, and this despite legal code and rules compelling the misconduct must be addressed in order for justice to be served. The full story identifying how lawyer Pamela Mills' professional misconduct successfully obstructed justice can be seen by clicking on the video link at the end of this video, or one in the description below. Able to see the misconduct fully explained on the other video, we will not repeat the facts again in this one other than to address what is being confirmed by the American lawyers, Michael Popock and Karen Friedman-Agnifilo, in one of their Legal AF podcasts. They discuss an act of perjury by a member of the Trump Organization, Alan Weisselberg. Except it's impossible to ignore the fact, what they are legally pointing out is also analogous to the lawyer misconduct by Pamela Mills and Roslyn Cogan. So like it or not, the Ontario Law Society now finds itself in the position where two top lawyers are pointing out legal duty and rules that it should have upheld over 10 years ago, but didn't. An egregious failure by our system. The Ontario public deserves much greater integrity from a law society charged with governing its own industry. But let us appreciate how unconscionable the legal failure has been and allow Michael and Karen to explain the situation that is applicable to be legally upheld here in Ontario, according to legal code and rules.
This is Michael Popock, and you know what time it is. Legal AF After Dark time. Judge Engoron presiding over the biggest death penalty financial threat to Donald Trump that exists, the $500 million or so disgorgement civil fraud case that's been pending against Donald Trump for the last year and a half. He's about to enter his ruling. We've been expecting it for over 3 weeks. We thought it was coming last week. But then something happened. The New York Times reported that one of the lead witnesses for Donald Trump, and more importantly, a defendant in the case, along with Donald Trump, a co-conspirator, if you will, named Alan Weisselberg, the disgraced felon of a chief financial officer for Donald Trump, might be ready to plead guilty to perjury. That means lying under oath in the very case that we're talking about. What could the impact of that be? What will happen with the Manhattan DA's office? You know who knows better than anybody? My co-anchor, Karen Friedman-Agnifilo, used to be a leader in the Manhattan DA's office, and we talked all about it on Legal AF. Take a listen. Let's return to that saga. I feel like I'm binge watching the episodic TV here when it comes to the civil fraud case. So let me tell you where we are, and then then you and I can bat it around, bash the badminton around a little bit, the shuttlecock around a little bit about the case. 11 weeks of trial, dozens of witnesses, experts for Donald Trump, all sort of rejected by the judge. Witnesses that testified, including many that for Donald Trump that the judge found to be incredible, uncredible, and not telling the truth, including Donald Trump himself in one scenario. Now it all comes and oral argument was held a month ago or 3 weeks ago, and we've been waiting on Judge Engoron to issue his judgment. Now, first we thought he was waiting to see the monitor's report for the monitor that he had installed 14 months ago, about what's going on currently in the Trump organization. Have they learned their lesson? Are they still committing fraud? How are they running their operation in the lab? Should I allow them to continue? Are they good Boy Scouts or Girl Scouts, or are they recidivists that I should punish? What is it? So he got that report, and we've done a lot of talking about and unpacking of that report, which was closer to a D to an F for the Trump organization than an A or a B. And so I said, well, he's probably waiting on that. And then we get the new bombshell. New York Times starts to report that Alan Weisselberg, the disgraced chief financial officer, already convicted of tax evasion and served 100 days in jail at Rikers Island, who testified. Yes, he was called adversely by the New York Attorney General, but he testified trying to help Donald Trump. Every time there was a question that would have hurt Donald Trump, he couldn't remember. Every time there was a question that could have helped Donald Trump, he suddenly grew a brain and memory banks and testified about it. And in real time, Forbes magazine had a headline that said, Alan Weisselberg just perjured himself because he lied about him pushing as a major part of the assets for Donald Trump the size of the triplex apartment in Trump Tower, which we have a picture up there, which is 1/3 the real, they tripled the size of it, speaking of triplex, and it went from being, maybe a $50 million apartment to on the books for Donald Trump, $150 million apartment, which, as you can all imagine, knowing math, that's a big swing to cook your books with. And he lied under oath, apparently, and said, I never told anybody that. I never pushed the size of it. I don't know what the size of it was. And Forbes magazine was like, yes, you did. You gave us an interview in Trump Tower in which you waved your arms around and said, look at this giant 30,000 square foot triplex. And of course, he had already testified and given sworn testimony to Karen's old office. And so the reporting is he's in plea discussions being led not by the lawyers for Donald Trump, but by his own counsel, Seth Klayman at Klayman Rosenberg, to maybe take a plea of perjury for testifying fraudulently inside of the courtroom with Judge Engoron. So Judge Engoron reads the paper. Nobody thought to inform Judge Engoron officially, like the lawyers. So he had to read it like in the morning paper. He came back to the lawyers with an urgent, high priority email. I love Engoron, and wanted a response in 2 days as to whether it was true, what impact it should have on his evaluating the credibility of witnesses like Alan Weisselberg, if he should just apply the legal doctrine that he's a liar and he lied about everything and do an adverse inference about it, and how that should impact the judgment. And as officers of the court, I want you all to tell me what happened here. Hint, hint. Did the lawyers for Donald Trump know he was lying and allowed it to happen, meaning they suborned perjury? Let me know. I want to get to the bottom of this. And so we got the filings, which just came in right before we got on the air. Karen and I got on the air tonight, which is from Alina Habba and mainly the New York Attorney General, Kevin Wallace, and Cliff Robert. Karen, did you get a chance to go through all those?
I did. I didn't think
why don't you take it from here then? Tell the audience about them.
Yeah, look, this back and forth about Weisselberg was fascinating because, first of all, having worked at the Manhattan DA's office and had the New York Times report on our big cases, typically the New York Times does not go out over their skis. I don't think they would have published this if they didn't have pretty good information that those discussions are going on. So that's number one. I think we have to assume that is happening at least at some level. And it was very interesting because some people would think that prosecuting perjury is easy. It's not, because it's like, oh, it's a liar. It's either you lied or you didn't, or you told the truth. But it's not always easy, because when you say things like, I don't recall, it's hard to prove memory, right? It has to be a material misstatement for you to be able to prosecute someone for criminal perjury. And the statement has to be under oath. So the easiest thing would be if you had testimony at the tax fraud case against the Trump organization that they got the 17 count conviction for at the Manhattan DA's office. The easiest thing would be in that trial where if Alan Weisselberg testified to something that he said, the apartment is, I know for sure, I went and measured it, the apartment is 10,000 square feet. But then he came and he testified to Judge Engoron, and I'm just making up the facts because what I didn't do is analyze the record in detail. I'm just giving an example of what could be perjury. And then in front of Judge Engoron, if he testified, no, it's actually a 30,000 square foot apartment, and he lied, right? That's a clear material misstatement of a fact under oath that I think could constitute perjury. The fact that I think they probably have the goods on him. I think there probably is something, and they're negotiating. What do we do? Because don't forget, this not only will impact the Attorney General's case, but this is going to impact the Stormy Daniels election interference case that's about to go, because Weisselberg is a witness in that case. And so, look, it's, when you are calling a witness who's a cooperator to the stand, and then you have to put out there that he's a liar and he committed perjury, he kind of is useless in a way, unless you can corroborate him, because the cross-examination of him is, you lied under oath, so why should we believe you? You're under oath now. I mean, he's a liar. And so it's not good for Alan Weisselberg that he committed perjury. He also could go to jail. They could rip up the cooperation agreement, and the cooperation agreement, which would say if you violate this, then there's some consequence. That could happen too, and might happen, and he might have to go back to jail. So Goron is right to want to know about it, and he talked about a concept in the law which is called falsus in uno, another Latin phrase that practicing lawyers, trial lawyers, are familiar with. And it basically means that if a witness lies about one thing, you can assume they lied about everything. It's actually a jury charge that we often ask for when we go to trial, and we're talking about what's the law, what are the charges that the jury is going to be read. And sometimes lawyers can ask for that if a witness if you find that a witness has lied under oath, you can choose to disregard everything they said and assume everything they're saying is a lie. And Judge Ngoran talked about that. I could do that. It's one of the things he could do, but that he obviously wants to know. And so the letters today, and he said, so parties, I read the paper, I want you to get back to me and tell me what your positions are, and tell me what the law is, and what should I do here. And the Attorney General's office said, basically, they wrote a letter and letter brief by Mr. Wallace, who basically said, look, what we have done in our office is what we have to do, which is we built a wall, and there is somebody who is dealing with the Weisselberg perjury criminal side of this and talking to the Manhattan DA's office. I'm on the civil side, and so that's what I'm dealing with, and we have to deal with it this way. But he basically cites a New York ethics rule 3.3 AC, which creates a disclosure obligation to a lawyer if they basically knowingly call a witness to the stand, or if their client, let's say, so here it's his client, but they didn't call him to the stand, right? The Attorney General's office called him to the stand. If they know, they're an officer of the court first and foremost. If you're a lawyer, right? You represent your client, but you also are an officer of the court. That's why you have to be an attorney in good standing of a particular court to be able to practice there. And so, because you have obligations, they're giving you permission. A court gives you permission to practice there. And if you're not barred in a certain jurisdiction, you have to ask for permission and be sponsored by a lawyer, because you have ethical obligations. And one of them is that you're not going to knowingly submit false information or suborn perjury to the court. And so the Attorney General reminded the court of the ethical obligation that Alina Habba has, that basically says, look, you have to disclose to the court if your client or a witness that you called gave a material falsehood, you're obligated to tell the judge. And what the Assistant Attorney General Wallace said was, look, we're unaware if there's any negotiations with the Attorney General and the DA's office, because I'm not handling it. That's being handled by someone on the other side of this confidential wall while that's happening. But Alina Habba, who is under an obligation to tell the court if that's the case. But her letter basically sets out the opposite, right? But I have a theory about why she did. She basically said, she wrote a letter that said, oh, I consulted with my ethics counsel and I'm constrained by providing more detail. Yes, my office represents Weisselberg on the civil matter, but we have nothing to do with the criminal. And I haven't discussed anything with the Manhattan DA's office. But she says, my ethics counsel says I can't give more information. First of all, that's not true. That misstates the law. But what I read from that is basically she knows Weisselberg lied. She knows and he probably admitted to her that he lied. And she's trying to figure out, what do I do? Because I have an obligation to the court, but I also have an obligation to my client. And so in some ways, by answering that way, by saying that for ethically speaking, I can't say anything, she's basically admitting that he did lie and she knows he lied. And I'll give you an analogous example. When in a criminal case, for example, if you're a defense attorney and you have a client and they told you a set of facts, and then they said to you that morning, I'm going to testify and I'm going to say a different set of facts, if as the lawyer, I have an obligation. I can't call that my client to the stand and allow him. I can't knowingly ask him questions knowing that he's committing perjury. But I also can't, because of attorney-client privilege reasons, I can't sell him out to the court. And so the way I handle that, the way attorneys handle that, is they say, they stand up and they say, Your Honor, my client has a statement with which he would like to, that he wants to make to the court. But I'm not going to ask him any questions. He is going to make a statement to the court. And the attorney steps back and sits down, because they are not suborning perjury. They are basically saying, my client is doing this and I'm not participating. And so everyone knows what that means. It's like code to the court. Hopefully the jury doesn't know, because you don't want the jury to be tainted. But it's kind of code to the court that he's lying. And so I read her letter to also be code. And she's basically saying, he lied, I can't say anything, but I'm basically admitting that he lied and committed perjury. And so that's what I think she was doing there.
Yeah, I think she's got a suborning perjury problem. The problem that they have is they've walked into the trap that's been laid by Judge Engoron. Judge Engoron didn't say that he took it as article of faith that the New York Times article was accurate reporting. He asked the lawyers, who are officers of the court, to give him the facts or information required for him to assess as the trier of fact whether we have a perjury problem and a suborning perjury problem in the courtroom. And instead, Cliff Robert ran out and did a crazy response, attacking the judge's ethics, of all things. Talk about the pot calling the kettle. And then, of course, they always love the whataboutism. You know who is a perjurer, Your Honor? Michael Cohen is a perjurer with no record cite, just an exclamation mark. He perjured himself in front of you. Where's the citation of that? Where is the proof of that? Nothing. It just undermines their credibility every time they write something into the court. And what the judge, I'm sure, is going to respond is, thank you for your submissions. The Trump lawyers seem to have missed the boat. I'll take Ms. Haba at her word that she cannot tell me more based on her ethical obligations, but also I need to get to the bottom of whether whether perjury has happened in my courtroom, independent from whether the crime of perjury is being prosecuted by the Manhattan DA. I have my own independent obligations as a judge to determine whether, as the trier of fact, somebody lied to me under oath. So I'm going to hold an evidentiary hearing and get to the bottom of it. If Alan Weisselberg wants to take the Fifth Amendment, fine. So the problem is he doesn't have, as we like to say in civil practice, he doesn't have all necessary and indispensable parties in front of him. He has Alina Habba, he has the lawyers for Trump. He doesn't have Seth Klayman, the lawyer for Alan. He doesn't have Alan Weisselberg in front of him again, who probably will take the Fifth Amendment on this particular issue. He doesn't have representatives of the Manhattan District Attorney's Office who may or may not be able to speak. And he doesn't have testimony under oath. You'll note, for those that are watching us, the audience, the letters we keep posting, the letters that were submitted, including the New York Attorney General, it's not under oath. They're not affidavits. They're on letterhead. They're on electronic letterhead of these law firms. So these are naked allegations and argument of counsel without any evidential support. I think they're just walking into the, if I'm Engoron, you can do one of two things. You can take the direction from the New York Attorney General, which is, yes, you got lied to. However, we know he's a liar. He went to jail already. We put him in jail already. The Manhattan DA put him in jail already. He served his time. You know he's not reliable. Get to the decision. Because they're chomping at the bit because they want the ruling. You know, they want the up to 500 million. Somebody said in the chat, why is it only up to 500 million? Well, it's got to be tied to, ill-gotten gains or profit that they should not have obtained. And there was a detailed calculus that was put on by expert witnesses for the New York Attorney General. Yes, the judge can increase that, but disgorgement is not punitive damages, and punitive damages are not at stake here. So there's a ceiling for this with interest, but he could give the benefit of every doubt to the New York Attorney General and ratchet that number up a bit. He could take that lead for the New York Attorney General, which is nothing to see here. Yes, you may have gotten lied to, but you knew you possibly were lied to by Alan Weisselberg of all people. Just issue the judgment. Or you could do what I think this judge is going to do, which is, I don't like the precedent of somebody lying to me in a courtroom, and I can't ignore it. I mean, I can't just cover my eyes, and my justice is blind, but it's not deaf and dumb. And he's going to have to do something about it because I think it just sets terrible precedent in the future for if they quote unquote get away with it.
Justice is blind, but it's not deaf and dumb. But the lawyers Pamela Mills and Rosalind Cogan have got away with fabricating a case for over 10 years. So what's going on? If not deaf, dumb, and corrupt, why will the Ontario Law Society not hold them legally accountable for their verified catalogue of code violations? Exactly. There is absolutely no excuse. And this is the problem with justice. It's only as good as the integrity of the people overseeing it. So let's get down to it. Why are the comments made by Michael Popock and Karen Friedman-Agnifilo analogous to the professional misconduct witnessed by the actions of the Canadian lawyers Pamela Mills and Rosalind Cogan? First, what is the Law Society of Ontario definition of professional misconduct? Professional misconduct means conduct in a lawyer's professional capacity that tends to bring discredit upon the legal profession, including a. violating or attempting to violate one of these rules, a requirement of the Law Society Act or its regulations or bylaws. B. knowingly assisting or inducing another legal practitioner to violate or attempt to violate the rules in these rules, the paralegal rules of conduct or a requirement of the Law Society Act or its regulations or bylaws. E. engaging in conduct that is prejudicial to the administration of justice. The list goes on. Indeed, the legal industry goes all out to encourage respect for the administration of justice, saying, a lawyer shall encourage public respect for, and try to improve the administration of justice. And more importantly, given this expose content, code states, a lawyer should not hesitate to speak out against an injustice. Except, that's exactly what the Ontario legal industry has failed to do en masse regarding this case. But what is the extent of this case injustice that is being ignored? The intricate facts can be seen by clicking on this end link, but the allegations can be broken down thus. Whilst giving this explanation, we will present just some of the Ontario legal code and rules that have been violated by Sheppel lawyers. All a matter of legal record, the case was initiated because of a Morneau Sheppel guidance counsellor malpractice. The counsellor, Catherine Heyman, defamed Bruce Edwards' name, and to the point, it destroyed his family, left him penniless and nearly got him killed, twice. The situation forcing him to represent himself in court, up against high-profile corporate lawyers, Bruce Edwards lost the case, despite his evidence being supported by the liable test. Making his loss even more surprising, Sheppel's factum did not identify Catherine Heyman to be defended. However, before he would start the case, the judge, Justice Blaby, was confused by the absence of Sheppel not naming Catherine Heyman to be defended in its factum. Pamela Mills very quickly assured him that everything in Sheppel's factum, although not naming her, was all legally pertinent to Catherine Heyman. Seemingly happy to take her word for it, Justice Blaby allowed the case to commence. While initially appearing plausible, Sheppel's factum statements failed to align, and as a result, after losing the case, it prompted Bruce Edwards to commission a private investigation, and outrageously, the investigation revealed Sheppel's defense of Catherine Heyman wasn't just flawed, it was entirely fabricated. Adding to the gravity of the situation, newly discovered evidence revealed that crucial on-point authority material facts, mandated by legal code to be disclosed to the court, were deliberately withheld, and worse, substituted and replaced by another authority of no legal pertinence to anybody in the case. Demonstrating the effectiveness of Sheppel's misinformation tactics, Bruce Edwards initiated an ethical inquiry with the legitimate licensing legislative authority that Pamela Mills' factum should have disclosed to the court at the time of the case. However, the outcome of the ethical inquiry offers ample reason why Sheppel concealed the on-point authority from the court. In stark contradiction with the Brampton court judgment, the official inquiry affirmed that Bruce Edwards' malpractice claim against Catherine Heyman was ethically justified. This position determines, it is evident that without lawyer misconduct, he should have rightfully won the case. Adding to the deception consequence, by Sheppel lawyers acting in bad faith, Justice Blaby's decision is now also left on legal record inexcusably siding with an utterly indefensible fantasy. Despite years of tirelessly raising this injustice issue with the Ontario legal fraternity, and officers of the court having a solemn duty to speak out against injustice, negligent silence still prevails. And despite solemn duty requiring the injustice to be addressed, it's a deeply unsettling reality for public consideration. But the fact is, if diligent investigation scrutiny had not been applied to the legal statements made in this case, it is almost certain the illegality of Pamela Mills' specious factum would never have come to light. And this inevitably prompts another serious question. With lawyers able to apparently conceal misconduct behind privilege, how many other instances of attorney misconduct lie shrouded behind the veil of privilege, eluding detection and undermining the integrity of our legal system? I said at the beginning of this video that the Edwards v. Morneau-Sheppel case was analogous to the comments made by Michael Popock and Karen Friedman-Agnifilo, but actually, the situation that the Ontario legal industry is apparently prepared to ignore is considerably worse. An unavoidable illegality that cannot be ignored by the Ontario legal industry. Based on verified investigation findings, Sheppel's factum did not contain material facts relevant to any party involved in the case. And a matter of legal record, Pamela Mills' improper pleading broke numerous ethical rules, broke disclosure obligation rules. She did knowingly state material falsehoods and misstatements under oath. She lied directly to the judge. She substituted official material facts. She did not concede to the court as to making material misstatements, and as a result, her contempt of the court did obstruct justice. Regardless of her legally astonishing abuse of privilege ignoring code rules, I understand first and foremost, Pamela Mills' abandonment of duty to the court cannot go unaddressed. The issue being, by Pamela Mills' false confirmation to Justice Blaby that Sheppel's factum was directly pertinent to Catherine Heyman, it clearly indicates that Mills knowingly misrepresented material facts. Indeed, to say, false as in false in one thing, false in everything, precisely encapsulates Pamela Mills' egregious display of bad faith. The perplexing reality deepens as the company she is affiliated, Ed and Burles, despite being apprised of her misconduct transgressions, they confirm they are standing with the court judgment, thereby compounding yet another integrity crisis within the fabric of our legal industry. This flagrant display of disregard for ethical standards within our legal profession only serves to further underscore the pervasive lack of integrity plaguing the legal industry. With nobody apparently willing to hold the lawyers legally accountable or intercede in this matter, the system can clearly be seen providing aid and comfort to lawyers who are corrosive to the rule of law. This unconscionable legal apathy underscores the need for transparency and accountability within the legal industry to maintain the integrity of the justice system, warranting unequivocal condemnation for promoting injustice within the judicial system. Through its failure to take action to ensure accountability for the lawyers who have violated oath of office, legal industry inaction has not only neglected its fundamental obligation to uphold legal standards and ethical codes, but has also provided aid and comfort for lawyers who are incontrovertibly implicated in obstructing justice, a situation that is deemed criminally unacceptable within the same legal framework that is ignoring the code violations. Speaking truth to power, when corruption infiltrates the legal profession, it erodes public trust in the legal system and undermines the fundamental principles of justice and fairness. Lawyers hold a position of trust that, if abused, can pervert justice, manipulate legal proceedings, and exploit vulnerable individuals who may lack the resources to navigate through a compromised legal process. Lawyer corruption is also responsible for deterring individuals from seeking legal recourse, fearing that their rights will not be adequately respected or that they will encounter further injustice within the system. Therefore, combating lawyer corruption is not only essential for preserving the integrity of the legal profession, but also for reinforcing the principles that guide a fair and equitable legal system, upon which society depends. For now, thank you for watching, and please follow the link for the full story. And may we wish you never have to deal with lawyer fraud.